We should be releasing 2 reports today from the Power Protector South Africa team that have been postponed to the 3rd. Both reports that have been postponed are reports that are dealing with whistleblowers, and both of them are complete and sitting on my desk. However, we discovered in the process of finalizing the release process that those 2 reports had not been served on 2 people that were crucial in respect of each. One relates to a whistleblower case at the Treasury in the KwaZulu-Natal government. The other one deals with an old whistleblower case at the estate agent board. Please bear with us that we've had to defer them. However, they will definitely be released on the 3rd as soon as we've received responses to the notices that we've saved on those 2 people and integrated and evaluated those responses. As you're aware, the media briefing was initially planned to take place 2 weeks ago. Again, it was postponed. You ask yourselves, why these days are we postponing our media briefings? We have 28 cases in courts where we're being reviewed. And one of the areas of attack are people saying they were not sufficiently consulted, or even when they were consulted and given all of the paperwork, they say they were not given adequate time. And that's the case, for example, with the KwaZulu-Natal one. The one person was honestly not given a notice before last week. The other person was given notices. We met with her, but she has been insisting that she hasn't been given adequate time. And because of avoiding a legitimate review, we have extended the timeline for them to comment, and are then prepared to release those reports on the 3rd of October this year, which is Monday, a week from now. Today marks exactly 14 days before the end of my non-renewable 7-year term of office, and naturally my team and I are racing against time to finalize several matters that the people of South Africa have entrusted us with. Contrary to popular belief, the workload that remains to be dealt with in the next 2 weeks is a mixed bag of cases that involve ordinary people as well as the so-called high-profile cases. Some of the matters that we are racing against time to finalize include a systemic investigation on the RDP program. You'll recall that we released an interim report and indicated that a final report would be provided. We also released an interim report on Millennium Development Goals, where we were doing a systemic investigation focusing on health and poverty. We're now finalizing the final report. We also conducted a systemic investigation on illegal conversion of panel vans. That too is being finalized. Pelindaba nuclear matter is in the process of finalization, as we have seen in the media. We're finalizing the Mandela funeral report. We're finalizing a report that is called CX, which is a report involving the conduct of the first democratic government when it received a report from an organization called CX. We are finalizing Hlasela 2, Prasa 2, Freddy Dairy Farm. We also have reports that are not being finalized, that are in the process of being dealt with, and one of those deals with allegations of impropriety, including corruption at SASA. Lastly, we are also in the process of finalizing a report into alleged state capture. All these investigations, we have some high-level drafts that are being cleared up and quality assured, and we're hopeful that we will meet our deadline. We welcome the curious but belated interest in one of these investigations, the so-called CX matter, which somehow has been connected to state capture. As you may recall, it's an old investigation that only 2 journalists had an interest in until we started the new state capture investigation. In which case, every time this investigation is being mentioned, it is linked to the concept of state capture. But just to clarify on that investigation, we're not investigating what happened during apartheid. We have no authority to do that. And anybody who had an interest in any event had 22 years of democracy to look into that. What we voluntarily chose to do in exercising the discretionary powers of the power protector was to review the conduct of the government of President Mandela on receipt of a so-called CX report. And we're just looking into whether or not that conduct was proper, as envisaged in Section 182 of the Constitution, or could constitute maladministration. As you know, the government had commissioned an investigation into CX. It had commissioned an investigation which was to be conducted by a company called CX, which is headed by a former member of the UK MI5, which is the equivalent of the CIA and the equivalent of our state security agency. We have made headway in that investigation and have interviewed virtually everyone that needed to be interviewed. An advanced draft of a report is being quality assured, as many other reports are currently being quality assured. In regards to this one, I do recall that there is one outstanding interview that still needs to be conducted. We are aware of unfounded allegations that I'm reluctant to investigate the matter. To these people who have recently gained interest in this matter, they just need to know that if I didn't want to investigate this matter, I wouldn't have. Because there's no law that forces me to investigate any matter. It's discretionary power, which is exercised after a thorough triaging process, and sometimes after a to-ing and fro-ing process, as it happened in this case. When I eventually decided to investigate this matter, it was because I thought there was reason to investigate it. And once we've decided to investigate a matter, we investigate it. In any event, if we didn't want to investigate it to conclusion, we still had another opportunity to issue a closing report, which by now we would have issued that closing report if we have no interest in investing. So these newfound gurus who have more interest in this matter than we do have are really false prophets. Firstly, they were there when this thing happened. Secondly, when Paul Hoffman initiated this investigation, they were not there to support it. And suddenly, their whole lives seem to depend on this matter. We wonder why. Another investigation that has been topical in the media is the so-called state capture investigation. Again, I want to clarify to those who have decided that this is now a ground for mudslinging, calling me an agent of white capital and all sorts of things, that I did not initiate this investigation. This investigation was initiated by a collective of Catholic priests of the Dominican Order, who alleged that the president had improperly allowed a particular family to influence the appointment of ministers in government and the appointment of members of boards or state-owned enterprises, and that this family and its companies were using undue influence to control tenders or to get themselves awarded tenders and to get undue payments to them. There was also an allegation that this family and its particular companies were being favored in licensing through organs of state. I had discretion to investigate or not to investigate. And whilst we're still considering whether or not to exercise that discretion favorably, another complainant filed a complaint. And the complainant that filed that complaint was a member of parliament who filed that complaint in terms of the Executive Members Ethics Act. And as you may recall, ladies and gentlemen, a complaint that is properly filed or properly lodged under the Executive Members Ethics Act does not give me discretionary power to say yes or no. If a complaint is filed in terms of the Executive Members Ethics Act, I must investigate. It was for that reason that I chose to investigate and duly requested resources from government and was given at least half of the resources that we requested. We requested 3 million, we were given 1.5, and it was said that should we need more, we may have to come back and make a request. We wanted to just clarify that, but I don't sit in a little corner and decide who or what to investigate. It's members of the public who are concerned about good governance that lodge these complaints. It is members of the Public Protector team in the intake and assessment unit within our complaints and stakeholder management branch that sit and go through these complaints and decide, do we have jurisdiction? And if we do have jurisdiction, should we exercise it favorably in terms of our discretionary power? Having been duly advised by that team, I then decide whether or not to proceed. But if it's an Executive Members Ethics Act matter, I have no option but to investigate. This brings me to the issue of, are we prioritizing any investigation? As some of these people that have started to accuse me of all manner of things have done. No, this investigation was assigned a particular team, and there are other teams that are conducting other investigations. And at the beginning of this month, I requested the Chief Executive Officer to work with the team to identify other reports that need additional resources, and to make sure that all of those investigations are resourced so that reports could be issued. In other words, we are not conducting any investigation at the expense of what we refer to as Gogo Dlamini cases. Indeed, the case that I'm going to report about today could easily be classified as a Gogo Dlamini matter. But just before I go into it, I thought I should address one thing. You probably are going to ask about it. These people that have just decided that they want to attack me from all corners have suddenly found an interest in my association with the South African Jewish Board of Deputies. Interestingly, they are aware that I've been dealing with the South African Jewish Board of Deputies for the last 7 years. In fact, the highlight of that relationship was last year when the South African Jewish Board of Deputies awarded me the Shivas Award in honor of Chief Rabbi Harris. And there was no problem. Nobody complained about it. And they went yesterday and issued a statement, incidentally after one of them inquired in my office about what was I doing in Durban, but didn't bother to collect the information properly. I'm now being accused of having fundraised for Israel. Just an honest assessment of the event, and an honest assessment of my invitation, which some of the people accusing me of that had access to, would have clearly clarified that the event had nothing to do with supporting Israel. The event was called to fundraise for an old age home in Durban. And they presented slides on the old age home, the current condition of the old age home, and testimonials from residents of the old age home, and indicated exactly what they wanted to do with the money, which was renovation at the center. But secondly, the invitation to the Power Protector was very clear, and we issued a media statement regarding that in the invitation, as we normally do. Clearly indicated that I will speak on the powers of the Power Protector, and the role of the Power Protector, and how can the public work with the Power Protector to protect the people. And that's all I spoke about. Now, the Constitution is very clear that the Power Protector must be accessible to all persons and communities. There is no provision in that Constitution to those who are attacking me that says no Jews allowed. There's no provision in the Constitution that says if you're a friend of Israel, the Power Protector must not be accessible to you. So good people, can we stop playing these games? It happens a lot when there's an investigation that people are not happy about, that people start lighting a fire behind my back. And we've seen people going to police stations accusing me of being a spy. I'm now being accused of being a supporter of Israel. For goodness sake. Firstly, I'm on record as supporting a two-state solution for Palestine. I'm on record as having spoken about the need for justice for everyone, for social justice in Palestine. I'm now being accused of endorsing what the Israeli ambassador said when he said it's important that Israel allows dialogue. What could be wrong with that statement? Because the ambassador was right, that the solution to the problems that we see in the Middle East and here in this country is dialogue, honest dialogue, and a commitment to social justice. And yes, I endorsed those views of the ambassador. I have no problems with Israel. If people have problems with Israel, that's their constitutional right to have. For me, all I'm interested in is justice for all, a peaceful world. That includes a peaceful world and a just world for both Palestinians and Israelis. We all have a right to have a particular view of the world, but please, good people, don't impose it on me. Not as a pub protector, not as a person, because as a pub protector, I am required to take a neutral stand. I can't have a sign on this building that says no Jews allowed, no friends of Israel allowed. However, I need to clear that because the schizophrenia that is taking place around all manner of accusations is trying to really distract me and my team from our work. Well, let those who are responsible know that we will not be distracted. We can't be distracted. We are employed to do our work. And our work we will continue to do without fear, favor, or prejudice. Lastly, if anyone is worried about anything, whoever you are, I give you my word. If you didn't do anything wrong, the report will vindicate you, whichever report you're concerned about. If you didn't do anything wrong, the report will vindicate you. It will be an open and transparent report like others that just talks about what really happened, what should have happened, is there discrepancy, and if there's a discrepancy, is it material enough to constitute improper conduct? And if so, what are we going to do about it? So please, good people, just calm down. Let's stop with the childish games. Then, going on to the report I am releasing today. As I've indicated, it is one of those Gogo Dlamini cases. However, it is a case that has systemic implications. The report deals with Eskom, and one member of the public that qualifies to be referred to as a Gogo Dlamini. Mr. Brian Modliffe, who is the Eskom Group Chief Executive, said on the 21st of July 2016, I quote, "Being customer-centric ties in with the principle of Watubili, which enjoins us to put people first by improving our efficiency and accountability to the recipients of services that we provide." Close quotes. Who tempered is my report as the Pub Protector, issued in terms of Section 182 of the Constitution of the Republic of South Africa, 1996, and Section 81 of the Pub Protector Act, number 23 of 1994. The report communicates my findings and the remedial action I'm taking in terms of Section 182 1C of the Constitution, following an investigation into allegations of maladministration by the Western Cape Operating Unit of Eskom Holdings, a state-owned company, which hereinafter is referred to as Eskom. The report deals with alleged wrongful disconnection of electricity supply to the premises of Ms. S. Kumalo on 29 February 2016, improperly imposing a tempering and reconnection fee of 12,000 Rand against her, and generally improperly handling the matter involving a faulty prepaid meter and use of unpaid electricity. The complaint was lodged by Mr. Sean Kumalo on the 1st of March 2016 on behalf of his mother, Mrs. Simone Kumalo, whom I shall refer to as Mrs. Kumalo. Mrs. Kumalo is a 49-year-old homeowner residing in Bongweni, Kayelisha, and she is employed as a general worker at a bus company. Her home is fitted with a prepaid electricity meter located inside her house. This ordinarily enables Eskom to obtain revenue in advance for the supply of electricity, and it allows Mrs. Kumalo to use whatever amount of electricity she may have pre-purchased and loaded onto her account. The respondent is Eskom, a critical state-owned enterprise which is entrusted with the responsibility to ensure that the entire electrical energy needs of South Africa are met economically and efficiently. Its role includes indirect and direct sales of electricity and collection of revenue in respect thereof. At the inception of the investigation, Eskom was asked to fix and reconnect the prepaid meter pending the findings of the Power Protector, but it refused to do so until the release of my provisional report in September 2016. The impact was that Mrs. Kumalo was unable to purchase prepaid electricity from the period of disconnection, which was 29 February 2016, until Eskom reconnected the electricity on 5 September 2016. The family was accordingly without the use of electricity at its residence for about 6 months. During the 6 months of inability to purchase prepaid electricity, Mrs. Kumalo relied on neighbors for some of the electricity needs of the family, using second industrial revolution energy mechanisms for household energy needs. The neighbors assisted Mrs. Kumalo with ironing the clothes and charging cell phones. For cooking, Mrs. Kumalo bought a gas stove and a paraffin heater to boil water. The investigation process commenced with an attempt at ADR, or alternative dispute resolution. Unfortunately, the person representing Eskom had not been given a mandate to settle, and the ADR did not achieve the requisite results. The conciliation process, though, did shed light on the factual circumstances that led to the complaint. During this process, Eskom conceded that it did disconnect electricity at Mrs. Kumalo's premises on 29 February 2016. Eskom further conceded that this happened 26 months after Mrs. Kumalo had reported a faulty meter to Eskom, advising that such faulty meter was preventing the family from loading prepaid electricity credit and instead allowing the family to use electricity without paying. Eskom further considered that a technician was sent to the premises of Mrs. Kumalo the same day when Eskom received the alert from the Kumalos. This was done without making prior access arrangements with the Kumalos. Eskom reported that the technician did not find anyone at Mrs. Kumalo's house, and that he was accordingly unable to fix the faulty meter. No further action was taken by Eskom until the follow-up visit on 26 February 2016. This was 26 months later. 3 days later, Eskom disconnected the prepaid electricity supply to Mrs. Kumalo. All parties did not dispute that after Eskom switched off the prepaid electricity at Mrs. Khumalo's residence, the matter was reported to NESA, which determined the tempering issue in favor of Eskom and the payment for used electricity in favor of Mrs. Khumalo. NESA placed a lot of emphasis on previous tempering and the fact that the box where the meter is housed was not sealed at the time the tempering determination was made. Regarding the payment of used electricity, NESA decided that it was Eskom's fault that such electricity was illegally consumed and unquantified. Eskom and NESA further submitted that the public protector has no jurisdiction on the matter, given the fact that NESA had duly dealt with it, and that if Mrs. Khumalo was not happy with NESA's determination, her only option was to approach a court of law. It is my considered view and finding that the argument that the public protector has no jurisdiction is inconsistent with the provisions of Section 182 of the Constitution, which only excludes court decisions from the public protector's remit. In my view, the public protector is an alternative to the courts, providing people without means, such as Mrs. Khumalo, whom we fondly refer to as Gogo Dlamini's, with a viable alternative to the scrutiny of actions of state functions. In my view, the public protector is an alternative to the courts, providing people without means, such as Mrs. Khumalo, whom we fondly refer to as Gogo Dlamini's, with a viable alternative for the scrutiny of actions of state functionaries and righting of administrative wrongs experienced through the conduct of state functionaries. The NESA Act, which precedes the Constitution, cannot trump the Constitution in this regard. I accordingly proceeded to review the acts of both Eskom and NESA on the understanding that the public protector does have power to review the conduct of state functionaries operating under the auspices of these institutions. The matter for my determination centered on Eskom's conduct regarding the determination of the cause of the malfunction of the prepaid meter, leading to consumption of electricity without pay or quantification, imposing of a tempering fine, and termination of access to prepaid electricity. Eskom submitted that the meter had been tempered by the complainant, hence the imposition of a temper fee, and in this regard cited the findings of the National Energy Regulator of South Africa, that is NESA. The complainant insisted that the family never tempered with the prepaid meter, that the box had not been changed by Eskom after fixing the damage caused in the previous tempering, and that had it tempered as alleged, it would not have reported the faulty meter, and advised Eskom that such meter was preventing the family from loading electricity credits while allowing it to use unpaid electricity. Just to clarify, the report does not dispute that the Khumalos had previously tempered with the electricity meter. It also does not dispute that the Khumalos had no right to free electricity. It also does not dispute that Eskom has the power and responsibility to make sure that people do not use electricity illegally. The issue at hand is whether or not the process followed by Eskom and later NESA was proper. or if that process constitutes maladministration. If the process constitutes maladministration, can we then say somebody was prejudiced by that process? On analysis of the complaint, the following issues were considered and investigated. Did Eskom wrongfully disconnect the electricity supply to Mrs. Khumalo's premises? Did Eskom improperly impose a tempering and reconnection fee on Mrs. Khumalo? Did Eskom improperly handle the alleged prepaid electricity meter malfunction matter? And did its conduct amount to maladministration? Was the complainant's mother or any other person prejudiced by the conduct of Eskom? And if so, what would it take to place the persons where they would have been had Eskom acted properly? The investigation process included the exchange of correspondence with relevant parties, meetings and interviews with the complainant and officials of Eskom and their service operating agents. There was also an inspection in local. After the initial investigation, Section 7(9) notices were saved on Eskom and NESA. A Section 7(9) notice is a notice alerting a party to evidence implicating that party and giving that party an opportunity to refute that evidence before a final determination can be made. Having determined on a balance of probabilities what happened, I contrasted the conduct of Eskom in this matter with the conduct that was required of Eskom in terms of the laws and other prescripts that regulate its conduct. The key laws and prescripts that informed my evaluation of Eskom's conduct were primarily those regulating the delivery of prepaid electricity, principles of administrative justice as envisaged in Section 33 of the Constitution, and the Promotion of Administrative Justice Act. I also took into account general principles of public administration as envisaged in Section 195 of the Constitution. In this regard, the conduct of Eskom relating to the alleged wrongful disconnection and imposition of a tempering and reconnection fee had to be in line with Section 33 of the Constitution, which incorporates a principle referred to as the alterum partem principle, that is, the right to be given an opportunity to speak in your defense before a decision that adversely affects you is made. I also took into account Eskom's conduct, and that such conduct should have been in line with Section 195 of the Constitution, which requires that certain basic standards of public administration, such as accountability and transparency, should be adhered to by all state functionaries. In this regard, I was also guided by the Constitutional Court's pronouncement in Khumalo versus MEC for Education. This is a 2013 case of the Constitutional Court, where the Constitutional Court said that a state functionary who is alerted to an irregularity or impending irregularity has a responsibility to take action to arrest such irregularity. In view of the matter being about the alleged tampering with the electrical apparatus and or interference with the supply, I also took into account the Revenue Protection Act and regulations under it. The Act stipulates a due process that should be followed before adjudicating such matters. In the light of the regulatory powers of NESA, I also took into account NRS 0471 of 2002, which is on electricity supply quality of service. This provides guidelines in respect of the procedure Eskom should have followed before disconnecting the electricity supply to Mrs. Khumalo's home. In addition to these regulatory instruments, I also took into account considerations of reasonableness, rationality, and fairness regarding the conduct of both Eskom and the complainant's mother throughout the process, from the moment the allegedly faulty prepaid meter was reported to the date on which Eskom disconnected the electricity supply. I'm grateful for the cooperation rendered by the General Manager of Eskom in the Western Cape, Mr. A. Lester, and the Eskom Group Chief Executive Officer, Mr. Brian Mulife, for the steps taken to remedy problems identified at the commencement of the investigation, and for ultimately reconnecting the electricity supply at Mrs. Khumalo's home on receipt of my provisional report. After examination of all of the evidence, I have reached the following findings. The first finding is regarding whether Eskom wrongfully disconnected the electricity supply, wrongfully disconnected the electricity supply to Mrs. Khumalo's premises. I find that the allegation is substantiated. I have provided reasons in the report, but basically the reasons are that the process followed was not fair, that she wasn't given an opportunity to present a defense in her favor, and that too much weight was attached to the fact that she had previously tempered and admitted to tempering. And Eskom did not take into account the fact that she is the one who reported the faulty meter. And secondly, that in her evidence, she said that the box was not sealed after the original tempering was fixed. I also took into account that Eskom waited for 26 months before it went back to Mrs. Khumalo's home. After she reported the matter, Eskom sent a technician, or so it says, who went there without making a prior access arrangement, and on not finding the family went back and reported that he had not fixed the meter because he had not had access. But for 26 months, nothing was done until Mrs. Khumalo applied for a second box to have electricity services at her house. When Eskom went to install the second box, it discovered that the family was consuming electricity without paying, and then proceeded to hold the family accountable for tampering with the meter. My determination is that Eskom's conduct regarding the handling of the process was in violation of Section 33 of the Constitution and Section 195, and that conduct accordingly constitutes maladministration as envisaged in Section 6 of the Power Protector Act and 182 of the Constitution. Regarding whether Eskom improperly imposed a tampering and reconnection fee on Mrs. Khumalo, I find that that allegation is substantiated. Because if the process of determining whether or not the meter was tempered by Mrs. Khumalo was faulty, a decision to say that she must pay for the tempering was also faulty. Again, my decision is based on a violation of PAJA in Section 33 of the Constitution, as well as Section 195 of the Constitution. And I find that the conduct constitutes maladministration and improper conduct. Regarding the general handling of this matter by Eskom, The allegation that Eskom improperly handled the matter is substantiated. For 26 months, Eskom failed to fix the reported prepaid meter malfunction, having been duly warned by Mrs. Khumalo that this was allowing unauthorized free use of electricity that should have been prepaid. This also resulted in unaccounted for consumption of available electricity at a time when electricity consumption planning has to become critical to prevent load shedding. Eskom's argument for imposing a tempering fine underscores the importance of preventing illegal connections and loss of revenue, which it claims to lose billions to. It is accordingly unclear how this anomalous situation was allowed to drag for this long, with loss of revenue in the process. 26 months of uncollected revenue is tantamount to a dereliction of duty on the part of Eskom, in violation of Section 195 of the Constitution and Section 51 of the Public Finance Management Act. It also is inconsistent with Eskom's financial stewardship responsibilities. I find Eskom's conduct in failure to collect revenue for 26 months to be clearly inconsistent with its statutory responsibilities. The conduct therefore constitutes maladministration in terms of Section 6 of the Property Act and improper conduct in terms of Section 182 of the Constitution. Regarding whether Mrs. Khumalo and other persons were improperly prejudiced by Eskom's conduct, I find that Mrs. Khumalo and her family were prejudiced by Eskom's conduct. Due to Eskom's failure to timely attend to the report regarding a malfunctioning prepaid meter and ensure the family had a functioning meter and did not consume electricity that is not quantified without paying for it, and uncertainty was perpetuated. And Eskom eventually prevented the family from lawfully buying and using electricity, a situation that persisted for 6 months. The outcome resulted in the family's inability to use convenient and clean energy in violation of Section 185 of the Constitution, requiring members to be informed in a timely manner about the disconnection of services. It can also be said that Eskom's conduct was at odds with Sustainable Development Goal number 7, requiring access to affordable, reliable, sustainable, and modern energy for all, the impact of which is to undermine environmental policies. Needless to say that those that pay for electricity may have been prejudiced by the offsetting of the unpaid electricity against their accounts. Regarding what it would take to place Mrs. Khumalo where she would have been had Eskom acted properly. In view of Mrs. Khumalo's knowingly consuming unpaid electricity for 2 years, knowing she was not entitled to free electricity, and without taking reasonable steps to mitigate her circumstances by following up or ensuring a follow-up on Eskom, I'm unable with good conscience to lay the blame entirely on Eskom or treat Mrs. Khumalo and her family as helpless victims of Eskom's dereliction of duty or improper conduct. Generally, my finding is that she did consume electricity that did not belong to her, and she had an opportunity to remind Eskom that the problem persisted. The remedial action I am taking in pursuit of Section 182(1)(c) of the Constitution is the following. Eskom, the General Manager of Eskom Western Cape, is to ensure that the tempering fee on Mrs. Khumalo's account is reversed, as such was imposed without following due process. 2, ensure that Mrs. Khumalo's liability with regard to the consumption of electricity without paying for it from 4 September 2013 to 29 January 2016 is calculated and reasonable terms are agreed to with her for the payment of the debt. 3, ensure that a mechanism is put in place to alert ESCOM of similar incidents where electricity is being supplied without necessary payment being rendered, and to take the necessary remedial action in that regard. 4, revise the standard operating protocol to ensure that each incident of reported faulty or illicit consumption of electricity is conclusively resolved, and that disciplinary action is taken in future against technicians who abandon a reported incident or faulty meter without certifying that such problem has been resolved. Regarding NESA, the remedial action is that NESA is to appoint an independent person to determine a fair value to be paid by Mrs. Khumalo for tempering and redo the investigation process properly, considering that the initial process followed by NESA was flawed. Basically, NESA has decided that the family should not pay for the electricity because it was ESCOM's fault that the family consumed electricity wrongly. But since everything that NESA was done has been found in this report to be proper because of the procedure followed, that means even the benefit extended to the family, that the family should get free electricity, falls away. The decision, therefore, is that the family should pay for the electricity, but should pay fair value for that electricity. Thank you.
Thank you, Public Protector. We have now come to the Q&A session, and I need a colleague to assist me with a roving mic. There he is at the back. Right. We will take the first round of questions and we will start. Do you have a roving mic? We will start with the front and we'll take the first 2 questions. Thank you. Question number 2.
Afternoon, Adv Thuli Madonsela, from the NCA. Adv Madonsela, why have you chosen to invite us to a press conference to release this specific report? Would you agree that this may have some strong political connotations, especially to your DTRAC? And what is your response to assertions that your support of Israel is essentially discounting the pain and suffering of the people of Palestine? And you mentioned that you might be taking action against those who allege that you and your team are a stooge of white monopoly capital and a CIA agent. Can you confirm if this is the case? And then lastly, will you be releasing a provisional report into state capture? And what assurances do you have that your successor will continue the investigation into its finality? And if Thuli Madonsela is reinstated as SABC COO, do you intend to take the matter further, and if so, how? Thank you.
Can I just respond on this one?
Nicholas asked many questions, and the people would like to respond before we move on to the next one.
Thank you. I thought because you've asked 5 questions, which is 5 people's questions, I might as well respond to you, Sam. Regarding ESCOM, I hope ESCOM does not take this political. In the report, I have acknowledged the assistance that was provided by the Chief Executive Officer of ESCOM and the head of Western Cape. It's just an issue of an anomaly that I think ESCOM needs to pay attention to. The reason we chose the report is twofold. One is it's one that we were 100% sure that we've consulted all of the parties. We have received all of the comments on our Section 79 notices, and we believe we're now on firm ground to release the report. That was the first part. The second part is that although it's a small Gogodlamini matter, it has systemic implications regarding how ESCOM follows up on alleged tampering or on alleged theft of electricity, which then affects the power supply or the planning of the power supply, because if you can't account for how many people are using electricity at any given time, then your planning of electricity supply is going to be affected. And it is in that spirit that we issue the report to advise ESCOM accordingly. We haven't received any negative vibes from ESCOM. Like most other organs of state, ESCOM defended its actions. However, I believe that the decision I've made is justified in the circumstances. The question regarding Israel, can I just have a confirmation again? What is the question?
I'm just picking up reaction to what you said earlier in the press conference, Advocate.
Yes.
And people such as the BDS groups assert that your support or at least neutrality towards Israel discounts the pain and suffering of the occupied people of Palestine.
Well, that's their opinion, and I disagree with them. I may disagree with some of the things that, let's say, the Botswana government does. For example, I don't agree with the death penalty in Botswana, but I have been to Botswana, and I have applauded the actions of the Botswana government on the things that the government does right. But my opinion on the death penalty is my personal opinion, and it's not fair to impose it on anyone else. I'm just using Botswana as an example. I could choose any country about things that I may not disagree with and things that I agree with. I do want to state categorically that I have no animosity towards Israel or any country. I do believe in a two-state solution between Israel and Palestine. I do believe that both the people of Israel and the people of Palestine deserve a decent life. They deserve to have their statehood acknowledged. They deserve to have their human rights and humanitarian law protected. If these people were really interested in my views on this matter, I have given various speeches on this matter, including on just issues of observance of what I refer to as humanitarian law. You may want to check my speech, which was given at the Institute for Cultural Diplomacy in Germany last year, where I dealt with these issues. People who are attacking for the convenience of attacking, to be fair, I don't think this thing has anything to do with Israel. I said so when somebody from the South African Jewish Board of Deputies approached me to apologize about dragging me into this. And my response to Mary Klug was, I'm the one who was apologizing to you because you've been hit in the crossfire. I believe this has nothing to do with Israel. I think this is just an attack that has been unleashed on me and this office. Regarding the CIA, I just believe that that particular issue is people, grown-ups behaving like children and just playing a game. And I've decided I really don't want to engage in that game. I really don't have the time. Right now, I will not deal with it. I will not do anything about it. I have said, as I said on EMCA this afternoon, if they want to play this game after the 15th, since I'll have a lot of time in my hands, I might just take them up on that game. But for now, I really have a job to do, and I'm not going to play these childish games. So for now, they can play as much as they want. I will not attend to that. But after the 15th of October, I may just play the game. On state capture, we are, as I've indicated earlier, doing our best to conclude this investigation and many others. We have anticipated that there will be leftovers, as there may be in some of the other investigations. The report we will issue will indicate what has been concluded and will indicate what will be outstanding. This we did with the PRASA report, where we indicated where we have conclusive evidence and we indicated where the matter needs to be taken further. And I believe then that my successor, who will be working with the same teams that are helping me doing this work, will have no problems proceeding with this investigation. Regarding Mr. Madonsela, I have indicated that to the minister that it would be improper to appoint Mr. Madonsela to the position of acting COO. If the court's view is that he's unfit to be a permanent COO, it doesn't make sense to assume that the court is saying he is fit to be an acting COO. Given the reason the court said he was unfit to be a permanent permanent COO was the finding that I made as a pub protector that he's a dishonest person. I have indicated to the minister in writing that should she or the board proceed with this matter, we will take this matter to court. We'll give instructions to our lawyers to sue both the minister and the board, and we'll ask for costs from them as individuals. Because that's not just disrespect for the pub protector, it's just disrespect for the courts in this country, and it is our duty as a pub protector South Africa to protect the rule of law and to ensure good governance in this country. Thank you.
From the Mail Guardian. Ma'am, you seem to be laying out a case for contempt in terms of your Empowering Act. You're talking about people who are trying to undermine the office, trying to undermine investigations that are currently ongoing. The previous instance that you described as such, you declined to initiate action based on contempt, saying that your investigation had already been concluded. To put it bluntly, are you thinking about contempt proceedings in this instance, finally pushing that button? And if not, the same question we asked at the time of Nkandla, at what point are you undermining your own office by declining to take that action? If I can throw in a second one, do you have an update for us on the criminal investigation around the invasion of your offices recently? Has the SAPS been in touch on that?
Thank you. We will allow the public protector to respond.
Thank you. No, I'm not laying ground, Mr. deferred, for contempt proceedings. Right now, my team and I have a job to do, which is to conclude the investigations we can conclude. Any distraction to start contempt proceedings, to sue people, would really be wasting our time. And in a way, it might be really falling into that trap where we are supposed to distract ourselves and start doing things that we shouldn't be doing. I will not do anything on contempt. The public, on the other hand, may institute contempt proceedings because the public protector protects the public, and the public can protect the public protector as an institution, not as a person. Because you correctly are saying that if there is contempt of the public protector, it's an institutional damage. It's not about the person. But for me personally, I consider this a joke, and the people who are doing this, I consider them childish. And I am not going to play any childish games with them. But since after finishing office, then I might have time, who knows, I might decide to be childish too. Thank you.
up closer.
Sipoma Brenner for the Times newspaper. Advocate, you have been quoted as saying you were considering taking legal actions against Corinne Maine. Could you please bring us to speed with this regard? Have you consulted and what was the advice? Thank you.
Thank you, Mr. Mabena. I did consult my head and decided no, that would be playing childish games with people, and I have no intention to play those games. But the answer that I've just given to Mr. deferred applies to you, sir, that should such childish games be played after the 15th of October, or from the 15th of October, who knows, I might just have a lot of time in my hands and might decide to join them in those childish games.